Okay, let's dive right into this. Welcome to this explainer, where we are looking at the absolute foundation of criminal liability. We're going to unpack the core mechanics of how the state legally proves a crime. Think of it as looking at the fundamental building blocks of criminal law in Pakistan, drawing straight from the bedrock principles of the Pakistan Penal Code. If you've ever wanted to know exactly how the justice system separates a tragic accident from a punishable crime, well, you are definitely in the right place.
Now, I want to kick things off by posing a question straight to you. Just think about this for a second. Can an act alone make you a criminal? Like, if your hands physically commit a prohibited action, is that it? Is that enough for the state to lock you up? I mean, the answer might seem like a totally simple yes, but the legal reality actually relies on an ancient, strict equation that demands a whole lot more than just a physical action.
The real answer actually lies in this incredibly famous Latin maxim, Actus non facit reum nisi mens rea. If you say it a few times, it honestly starts to sound a bit like a magic spell, right? But its translation is quite literally the ultimate bedrock of criminal justice. It means an act does not make a person guilty unless the mind is also guilty.
And that translates perfectly into what we call the twin pillars of criminal liability. Act plus mind equals crime. You've got the physical act, which is the actus reus, combined with the culpable mental state, the mens rea. And what you absolutely must understand here is that both halves of this equation are mandatory, no exceptions. You literally cannot have a crime with just one.
To see just how seriously the courts take this, we've got to look at the landmark Supreme Court case, Kaniz Fatima versus Wali Muhammad. In this ruling, the Supreme Court made things crystal clear. The prosecution has to prove both the act and the mind beyond a reasonable doubt. If a trial court convicts someone just because the physical act is proven, but completely ignores whether the required mental element was actually there, that is a fatal legal error. The whole case just collapses. The mental element isn't just some legal formality. It is the very essence of guilt.
All right, let's look at Section 1, Variable 1, Actus Reus, or the guilty act.
So let's break this down. What exactly constitutes a guilty act in the eyes of the law? You know, surprisingly, a guilty act isn't just pointing a weapon or stealing a car. It encompasses everything about the accused's conduct, and it generally takes three main forms. First, you have positive acts, doing something prohibited. Second, omissions, which actually means doing absolutely nothing. And third, a state of affairs, which means simply existing in a specific prohibited situation.
Now take a look at the sharp contrast here between a positive act and an omission. A positive act is pretty simple, right? It's a voluntary, physical action. But an omission? That's tricky. You can only be held criminally liable for doing nothing if you have a strict legal duty to do something. A moral duty just isn't enough. That duty has to come from a statute, a contract, or a special relationship like a parent to a child.
Let's look at a real-world example to really make this stick. Imagine you've got a security guard who's been hired to watch a warehouse. He falls asleep on his shift, and wouldn't you know it, a burglary happens. Because he had a contractual, legal duty to stay awake and guard that property, his failure to do so, his omission, can totally serve as the actus reus for criminal negligence. But what if a random stranger is just walking by, sees the burglar, and does absolutely nothing? That stranger commits no crime. They had zero legal duty to act.
Then we have the third form of actus reus, a state of affairs. These are basically situational offenses. You don't even have to voluntarily do anything in the moment. You just have to be in a prohibited state. The classic example is possessing unlicensed weapons. The actus reus is fulfilled simply by the fact that the weapons are in your possession. It doesn't matter if you aren't actively doing anything with them.
Moving right along to Section 2, Variable 2, Mens Rea, the guilty mind.
Now we're getting into the inner workings of the accuser's head. This is where the Pakistan Penal Code, the PPC, truly weighs a person's culpability. The law doesn't just broadly ask, did you mean to do it? Oh no, the PPC actually ranks mental states in a very strict hierarchy. At the very top, representing the highest culpability, is intention, where you actively desired the consequence. Just below that is knowledge, so you didn't necessarily desire the outcome, but you were fully aware it was almost certain to happen. Then we drop down to negligence, where your conduct simply fell below a reasonable standard. And for things like property and document crimes, we have specific mental states like acting dishonestly, meaning you intended wrongful gain or loss, or fraudulently, meaning you had a pure intention to defraud someone.
And let me tell you, the distinction between these levels is absolutely massive, especially when we compare intention and knowledge. In Section 302 murder cases under the PPC, this specific distinction literally dictates how severe the sentence is going to be.
If the state proves intention, well, that's Section 302A, the highest degree of murder. But if they only prove knowledge, meaning the accused knew their act was imminently dangerous but maybe didn't specifically desire the death, that falls under Section 302B. It fundamentally shifts how the court assesses culpability and exercises their sentencing discretion.
Which brings us to Section 3, the plot twist, strict liability.
Okay, so you've got the formula down, right? Act plus mind equals crime. But just when we've nailed down the rules, bam, the law throws us a massive curveball. Enter the concept of strict liability. In a strict liability offense, the mind suddenly doesn't matter at all. The prosecution only has to prove the physical act, the Actus Reus. Your Mens Rea, completely irrelevant to your guilt. Now, why on earth would the law do this? For ultimate public safety. For certain highly regulated, potentially dangerous activities, the state basically decides that the burden of proving what was inside someone's head is just way too high, and protecting the public has to come first.
You're going to see this in very specific, highly regulated areas. Examples include food adulteration, where, say, selling poisoned food is a crime regardless of whether you actually knew it was poisoned or not. It also includes specific narcotics possession under the CNSA, and includes customs offenses. In the Supreme Court case, Collector of Customs v. Mezer's Gold Dealers, the court ruled that merely possessing smuggled goods is enough for a conviction. The state absolutely does not have to prove you knew they were smuggled. The act alone seals your fate.
All right, let's pivot to Section 4, the link. Causation. Now, outside of those rare strict liability exceptions, let's jump back to our main formula. Let's say you've got the guilty act and the guilty mind. Well, the state's job still isn't over. They have to prove that your specific act actually resulted in the crime. They have to prove causation. Causation is this unbreakable factual and legal chain. First, you have the act. Then the court applies the but-for test for factual causation. But for the accused's act, would the consequence have happened? If the answer is no, we move to legal causation. Was the act the legally significant direct cause of the harm, or was it too remote? Only if that chain holds up all the way from step 1 down to step 4 can the state actually secure a conviction. Now, causation brings up some really fascinating legal doctrines, like the thin skull rule. Imagine you punch someone intending just to bruise them, but completely unbeknownst to you, they have a rare pre-existing medical condition, a literally thin skull, and the punch kills them. Under the law, you cannot argue that their death isn't your fault just because they were fragile. The rule is strictly this: the accused takes the victim as they find them. You are fully responsible for the fatal consequence in that causal chain.
But wait, what happens if something actively interferes with that chain? Say someone is attacked, goes to the hospital, but then dies because the doctors mess up. Does the original attacker just get off the hook? Well, the Supreme Court tackled this exact scenario in Ghulam Hussain v. State. They ruled that normal or even slightly negligent medical treatment does not break the causal chain. The original attacker is still on the hook for the death.
So the absolute crucial point here boils down to this Latin phrase, novus actus interveniens, a new intervening act. For an attacker to be absolved of a resulting death because of bad hospital care, that medical intervention has to be grossly extraordinary. I mean, it has to be so spectacularly negligent that it completely severs the link between the original wound and the death. Only then does the chain break, which could potentially lower the attacker's liability from murder down to just grievous hurt.
Finally, Section 5, the burden of liberty. When we take a step back and really look at this entire framework, what we are actually seeing is the immense burden the state carries on its shoulders. To lawfully take away a citizen's liberty, or even their life, the state cannot cut corners. They have to strictly, undeniably prove the Actus Reus, they have to prove the specific Mens Rea, and they have to prove an unbroken chain of causation. It is a monumental task by design, because the stakes are absolute. Which leaves us with a pretty provocative thought to end on today. If the legal formula for taking a life or liberty is this strict, requiring such immense precision at every single step, how often does the procedural machinery of our system get the math wrong? That is exactly the question that transitions us from substantive law straight into the complex world of procedural law. Keep this secret formula in mind, and I look forward to unraveling those procedures with you in our next explainer.